When you think about estate planning, the focus is often on wealth and assets. But what about debt? Unaddressed, debt can erode the legacy you've worked so hard to build, leaving your loved ones with unexpected burdens. In this video, we're tackling a critical yet often ignored aspect of estate planning: incorporating debt into your wills and trusts. Whether it's mortgages, loans, or credit card balances, managing debt within your estate plan is key to ensuring your assets are protected and your wishes are honored. Join us as we explore how to safeguard your financial legacy by making your estate plan debt-conscious. This is more than just planning. It's about securing your future and the future of those you care about. Guidance on incorporating debt considerations into wills and trusts. Incorporating debt considerations into wills and trusts is a crucial aspect of estate planning to ensure that debts are properly managed and settled upon the individual's passing. By addressing debt in estate planning documents, individuals can help protect their assets and ensure a smoother transfer of wealth to their beneficiaries. Here is a detailed section on guidance for incorporating debt considerations into wills and trusts. Identifying and documenting debts. The first step in incorporating debt considerations into wills and trusts is to identify and document all outstanding debts. This includes mortgages, credit card debt, personal loans, and any other financial obligations. It is important to gather all relevant documentation, such as loan agreements and statements, to accurately assess the total debt amount. 2. Prioritizing debt repayment. Once the debts have been identified, it is essential to prioritize debt repayment in the estate plan. Certain debts may have higher priority, such as secured debts like mortgages, which may need to be settled first to prevent the loss of assets. By outlining a repayment plan in the will or trust, individuals can ensure that debts are settled in an orderly manner. 3. Establishing debt settlement provisions. In the will or trust, individuals can include specific provisions for settling outstanding debts. This may involve setting aside a portion of the estate or specific assets to be used for debt repayment. By clearly outlining these provisions, the executor or trustee will have guidance on how to handle the debts after the individual's passing. 4. Designating debt payment responsibility. It is important to designate who will be responsible for managing and settling the debts in the estate plan. This could be the executor of the will or the trustee of the trust. By appointing a reliable individual to oversee the debt repayment process, individuals can ensure that their wishes are carried out effectively. 5. Considering tax implications. Debt repayment in estate planning may have tax implications that need to be carefully considered. Certain debts, such as mortgage debt, may have tax benefits, while other debts may result in tax consequences for the estate or beneficiaries. Consulting with a tax professional can help individuals understand the tax implications of debt repayment and plan accordingly. 6. Reviewing and updating. Lastly, it is important to regularly review and update the debt considerations in wills and trusts as financial circumstances change. Life events such as marriage, divorce, or the acquisition of new debts may impact the estate plan, necessitating revisions to ensure that debts are adequately addressed. By incorporating these guidance points into wills and trusts, individuals can effectively manage and settle debts as part of their estate planning process, ensuring a more secure financial future for their loved ones. Ensuring debt obligations are addressed in estate planning documents. One of the crucial aspects of estate planning is ensuring that debt obligations are properly addressed in the estate planning documents. Failing to account for debts can lead to complications and financial burdens for your beneficiaries. Here are some key considerations to keep in mind when including debt obligations in your estate planning documents. Identifying and documenting debts. The first step in addressing debt obligations in estate planning is to identify and document all existing debts. This includes mortgages, car loans, credit card debts, personal loans, and any other outstanding liabilities. Make a comprehensive list of all debts, including the creditor's name, outstanding balance, interest rate, and monthly payment amount. 2. Reviewing debt repayment strategies. Once you have identified all debts, it is essential to review your debt repayment strategies in the context of your estate planning. Consider whether it makes sense to pay off certain debts during your lifetime, or if they can be settled from your estate after your passing. Evaluate the impact of debt repayment on your overall financial plan and the inheritance you wish to leave for your loved ones. 3. Incorporating debt provisions in your will or trust. To ensure that debt obligations are addressed in your estate planning documents, consider including specific provisions related to debt repayment in your will or trust. Clearly outline how outstanding debts should be settled from your estate assets, whether through liquidating certain assets or using life insurance proceeds. 4. Designating responsible parties. When addressing debt obligations in estate planning, it is important to designate responsible parties who will be in charge of managing and settling your debts after your passing. This may involve appointing an executor or trustee who will oversee the debt repayment process and ensure that creditors are paid in a timely manner. 5. Communicating with beneficiaries. It is also important to communicate with your beneficiaries about the debt obligations included in your estate planning documents. Make sure they are aware of any outstanding debts that may impact their inheritance and provide clarity on how these debts will be handled. Open communication can help prevent misunderstandings and disputes among family members. 6. Regularly reviewing and updating your estate plan. Debt obligations can change over time due to various factors such as taking on new loans, refinancing existing debts, or changes in financial circumstances. Therefore, it is crucial to regularly review and update your estate plan to ensure that it accurately reflects your current debt situation and addresses any changes that may impact your beneficiaries. By taking these steps to ensure debt obligations are properly addressed in your estate planning documents, you can help protect your assets, minimize financial burdens for your loved ones, and ensure that your final wishes are carried out effectively. Consulting with a qualified estate planning attorney can also provide valuable guidance and assistance in navigating the complexities of debt management in estate planning. Provisions for debt repayment and distribution in estate plans. One of the key considerations in estate planning is ensuring that debts are properly addressed and settled upon the individual's passing. Failing to account for debts can lead to complications in the distribution of assets and may result in financial burdens for the beneficiaries. Therefore, it is essential to include provisions for debt repayment and distribution in estate plans to facilitate a smooth transition of assets and liabilities. 1. Identifying and documenting debts. The first step in addressing debts in estate planning is to identify and document all outstanding liabilities. This may include mortgages, car loans, credit card debts, medical bills, and any other financial obligations. It is important to gather all relevant documents, such as loan agreements and statements, to accurately assess the total debt amount. 2. Prioritizing debt. Repayment. Once the debts have been identified, it is crucial to prioritize repayment based on various factors such as interest rates, creditor preferences, and legal obligations. High-interest debts or secured loans may need to be paid off first to avoid accruing additional interest or risking asset seizure. 3. Allocating assets for debt settlement. Estate plans should specify how debts will be settled using the individual's assets. This may involve liquidating certain assets, such as real estate or investments, to generate funds for debt repayment. Careful consideration should be given to the impact of asset liquidation on the overall estate and the beneficiaries. 4. Establishing a debt repayment schedule. In some cases, it may be necessary to create a debt repayment schedule outlining timelines and amounts for settling outstanding debts. This can help ensure that debts are paid off in an organized manner and prevent any delays or confusion among beneficiaries. 5. Creating a contingency plan. Estate plans should also include a contingency plan for unexpected debts that may arise after the individual's passing. This could involve setting aside a portion of the estate as a contingency fund to cover any unforeseen liabilities or disputes that may arise during the probate process. 6. Communicating with beneficiaries. It is important to communicate with beneficiaries about the existence of debts and the proposed plan for debt repayment. Transparency in estate planning can help avoid misunderstandings or conflicts among beneficiaries and ensure that everyone is aware of their rights and responsibilities regarding the estate's debts. Including provisions for debt repayment and distribution in estate plans is essential for ensuring a seamless and efficient transfer of assets to beneficiaries. By carefully considering and addressing debts in the estate planning process, individuals can protect their assets, minimize financial burdens on their loved ones, and facilitate a smooth transition of wealth to the next generation. Collaborating with legal and financial professionals to draft debt-conscious estate planning documents. Collaborating with legal and financial professionals is essential when drafting debt-conscious estate planning documents. By working together, you can ensure that your estate plan is comprehensive and tailored to your specific financial situation. Here are some key considerations for collaborating with professionals. Legal expertise. Legal professionals, such as estate planning attorneys, can help you understand the legal implications of your debts on your estate plan. They can provide guidance on how to structure your estate plan to minimize the impact of debts on your beneficiaries. For example, they can advise on strategies to protect your assets from creditors, such as setting up trusts or using certain types of ownership structures. 2. Financial expertise. Financial professionals, including financial planners or advisors, can help you assess your overall financial situation and determine the best strategies for managing your debts within your estate plan. They can provide insights on how to prioritize debt repayment, optimize your assets, and ensure that your estate plan aligns with your financial goals. 3. Debt analysis. Together with your legal and financial professionals, you can conduct a thorough analysis of your debts to understand the extent of your liabilities and how they may impact your estate. This analysis can help you identify which debts should be prioritized for repayment and which can be managed through other means, such as insurance or asset protection strategies. 4. Customized solutions. Collaborating with professionals allows you to create a customized estate plan that takes into account your specific debts and financial circumstances. By working together, you can tailor your estate planning documents to address your debts while also ensuring that your wishes for asset distribution and wealth transfer are met. 5. Ongoing review. It is important to regularly review your estate plan with your legal and financial professionals to ensure that it remains up to date and reflects any changes in your financial situation or debt status. By staying proactive and collaborative, you can make adjustments to your estate plan as needed to effectively manage your debts and protect your assets for future generations. Collaborating with legal and financial professionals is crucial when drafting debt-conscious estate planning documents. By leveraging their expertise and working together, you can create a comprehensive and effective estate plan that addresses your debts while achieving your long-term financial goals. Incorporating debt into your estate planning documents isn't just a financial necessity. It's a critical step in protecting your legacy and securing the future of your loved ones. By proactively addressing debt in your wills and trusts, you ensure that your assets are distributed according to your wishes and that your beneficiaries aren't burdened with unexpected financial obligations. Remember, estate planning is about more than just passing on wealth. It's about passing on peace of mind. Take control of your financial future today and leave behind a legacy that truly reflects the care and foresight you've invested in every aspect of your life. Your loved ones will thank you for it.